You're going to be put inside that vessel. You're going to be taken to the country from wherever that vessel came from, whether it is from China, from Africa, from Russia, and you're going to be prosecuted. For the Honorable Panel of Judges at the International Court at the Peace Palace at The Hague, who has a seat on the Permanent Court of Justice, the evidence is in the record. Forensic evidence on the record of trespassing, willful trespassing, malicious prosecution. So if you were trespassing to one of these vessels, you're going to be charged with trespassing. What do we have in front of us? How many judges we have in front of us? How many lawyers we have in front of us? Vincent Serafino, you are a trespasser. Cindy and Mercer, you are a trespasser. James Lawrence Sanchez, you are a trespasser. You were told in writing. Did you speak the language? Did you read the document? Every document has a purpose. In your business, in your line of business, you should know. You should know. You knew or you should have known. If you knew, it's malicious prosecution with the intention to harm. If you did not know, it's negligence. You lose both ways. You are insured. How much money do you have in your pockets to bail you out of this situation? In the maritime contract, RE, Romeo, Echo, 119-486-83 US. It was clearly specified in English, on second grade English, that you were trespassing. And for the Honorable Adelina Arriaga Pedrosa gave you the opportunity to withdraw. Did you? Did you withdraw? No. Did you continue? Yes. Forensic evidence of willful, malicious prosecution with the intention to harm. What is this? Would you like for one of your kids to be prosecuted for something he did not, something that he didn't understand? Could he be prosecuted in China, on Chinese? For something he did not do? Can your wife be prosecuted in a foreign language? You heard it from the master. It hasn't been challenged. I don't think you can challenge. And it's not that I don't think, it's that you cannot challenge. You were given the opportunity. You did not challenge. And as I gather, we received a document, another document, where you continue. You continue. You don't know when to stop. And this is the shameful part. You went to school. You went to school for this, didn't you? What did they tell you at the university? You trespass regardless. The world is yours. We'll give you immunity. Well, I am presenting this court, the International Court, with this document, and I'm going to be a bit generous with my time so that you can take a screenshot for your convenience and read it. I'm going to go over and slide it up slowly. So now you get an idea of exactly what was sent to them. And on this document, Registered mail, certified mail, article number 70191640000105956727. Received mailed, stamped December 30th of 2019. Forensic evidence. New Year's Eve for the Honorable Avelina Arriaga Pedrosa doesn't have a holiday, doesn't have a family, doesn't have a celebration. While these trespassers were celebrating, she was sitting on front of my desk under a tremendous amount of stress, mental anguish, despair. While we wrote this document. For the Honorable Avelina Arriaga Pedrosa, UCC 1-308, 1-103 and 109. P.O. Box 2441, Los Lunas, New Mexico. XXXXX dash 99 dash 98. Hereinafter claimant versus Wells Fargo NA, Thomas M. Sellers and Mark Wegner, attorneys at law, and all parties listed on attachment 1 of case number Delta 1314 dash Charlie Bravo 2019000392. She also stated to be one of the people. One of the people. Right here. One of the people. Do you deal with people? Do you practice law for people? Do the legislation makes law for people? Since when? And by which code? Do you have a code that you can present? This document was filed in 2019 on 26th of December at 11:55 a.m. with 46 seconds. Total pages, 1. For the Honorable Avelina Arriaga Pedrosa paid $25 to have it filed and stamped, recorded, and it is a judgment of default because it is your fault. We dismiss this with all the authority, with her authority. This was dismissed. And it reads, judgment of default. Notice of default judgment. 1 Avelina hyphen Arriaga colon Pedrosa petition for entry of default by the notary against correspondent Wells Fargo NA, comma, Thomas M. Sellers, Mark Wegner, attorneys at law, and all parties named on attachment 1 for correspondence failure to rebut the claim, notice of dismissal. We dismissed this with prejudice on December 10th of 2019. Prejudice. Filed on the 10th of December of 2019. Wherein claimants demanded a rebuttal by affidavit within 15 days of receipt of this notice with prejudice. The correspondence has instituted no rebuttal. No rebuttal. You couldn't rebut this. No rebuttal by affidavit. Therefore, correspondent has acquiesced, and it is in statutory default. This default notice shall evidence that for the Honorable colon Adelina hyphen Arriaga colon Pedrosa is correct in her analysis of law and other inquiries contained within the natural human person, the claimant is without judicial standing, as no controversy on law or material fact between the parties exists. It is hereby ordered the surrender of all performance and replevin bonds no later than the 15th day of January of the year Lord 220, or a bench warrant will be issued. Autograph by the Honorable and for the Honorable colon Adelina hyphen Arriaga colon Pedrosa period. Reservation of rights under the Uniform Commercial Code 1-308, 1-103, and 109. Federal Postal Judge sui juris and one other people. This seal is there for a reason. It is sealed. Did you object? Did you came back and say, no, she's not one of the people? We have evidence that she's not one of the people. This seal here is her trademark. Order of default judgment. Default is entered in this action against all correspondents named on the foregoing petition failure to serve or file any paper as required by law. What kind of plane do you game? What kind of game do you play? When you send someone a solicitation and the solicitation is rejected under all those facts, and when your authority is questioned, your jurisdiction is questioned, and when you cannot come back and prove any different, the record shows nothing in that regard. It was notarized on December 26th of the year 2019 by the Honorable Official Seal of the Honorable Michelle Vasquez, Notary Public, State of New Mexico. Her commission expired on 11/10/20 of the year 2020. This is a good document. It was directed to you autographed, sealed, delivered, recorded. In the certificate of service on the bottom part, one Adelina Arriaga Pedrosa hereby certified that a true or correct copy of this petition for default, and default was served by certified mail, article number 7019-164. 0000105956727 by the United States Postal Service on this 30th of December of 2019 to Wells Fargo NA, Thomas M. Seller, and Mark Regner, attorney at law, and all parties named on attachment 1. Witness by the Honorable a special master in common law appointed by the Superior Court by an authority for the Honorable Adelina Arriaga Pedrosa, who is a federal postal judge sui juris, And it was witnessed by the Honorable J. Jesús, period, column, Jesús, hyphen, Arriaga, column, Abonce, period, who also reserved his rights under the Uniform Commercial Code 1-308, 1-103.6, and 109. Witness the Superior Court seal. It is also autographed by the Honorable and for the Honorable Adelina Arriaga Pedrosa, with reservation of rights under the Uniform Commercial Code 1308, 1-103 and 109. Federal Postal Judge sui juris and one of the people. This is human trafficking. Willful human trafficking. You were requested to provide a rebuttal. You did not rebut. Now, Cindy, the worst part here is for you, Cindy M. Mercer. You went to law school. You are a judge. You went to judge school. What did they tell you in judge school, Cindy M. Mercer? That if a lawyer came over here with an unsworn statement, you could accept it? For you. Philip Romero, are you trained on the subject? Are you a lawyer? You stated no, you're not a lawyer. You know nothing about administrative law. You guys are working on concert. You guys are an organization. You guys are organized crime. You guys are terrorists. You don't have an oath that satisfies the 6th article of the Constitution. You were given the opportunity on the federal court under case number 1, column 20 dash Charlie Victor dash 00113 dash Juliet Hotel Romeo. You were given the opportunity to withdraw. You didn't. You were given the opportunity to come and essentiate. You didn't. And on this document we read yesterday, Cindy M. Mercer, you flank every single answer on this. In fact, it was never rebutted. And for you too, James Lawrence Sanchez, pseudo judge, thief, who doesn't have an oath that satisfies the Article 6 of the Constitution, who is in violation of Title 4, U.S. Code Section 101, who is also in violation of 1 Stat 23, page 1, Section 1. And in the criminal complaint, we listed all these titles that you were in violation of. We read this document yesterday. And we are going to read it for the second time. This is a formal request and command for all to produce for the record the physical documentation of your delegation of authority. You didn't. As proof of jurisdiction is required by law pursuant to Article 3, Section 1 of the United States Republic Constitution. Did you provide it? No. This administrative notice and demand form is not intended to hinder, delay, obstruct, intimidate, harass, or in any way threaten anyone, but it simply means invoking recipient's duty to act pursuant to the below quoted instructions, i.e., laws, cases, and statutes, which apply to the recipient in recipient's official capacity for lawful disclosure of vital information, needed information. Should recipient not timely and fully comply, will be deemed by tacit procuration. Your implied consent you imply consent to a challenge, pursuant to a petition or writ of quo warranto, 63 American Jurisprudence, second 5, 441, to your authority in a court of correct jurisdiction. Information needed. 1. Oath of office, Title 15, U.S. Code Section 331. Item 2. Officer affidavit under Title 5, U.S. Code Section 332, and or on Item 3, employee affidavit under Title 5, U.S. Code Section 3333. 4. The surety bond, Title 5, U.S. Code Section 2901. And Item 5, registration of Title 22, U.S. Code Section 611 and 612. You never provided that. You couldn't provide that. In fact, this document here was filed on February 8th of 2020. Res judicata. Higgins versus Levine. This is good standing decision by the Supreme Court for the United States that cannot be turned by any thief. You're warring against the people that hire you, if they did hire you, indeed. You're warring against the Constitution. We have you signed treason against the people. You're going to jail for the rest of your life, of your natural life. I am positive that the panel of judges at the International Court are witnessing this video, and they are not going to side for you. They will not. In fact, they can't, unless they want to join you to eat potatoes at the federal prison where you're going for the rest of your life. On Higgins versus Levine, 415, uniform dot Sierra dot 533, there is no discretion to ignore lack of jurisdiction. Joyce versus the U.S., 474 second 215. The law provides that once a state and federal jurisdiction has been challenged, it must be proven. Martin versus Thibault, 100, period. Sierra, capital, period. Charlie, capital. Tango, lowercase, period. 2501 of 1980. Jurisdiction can be challenged at any time, and jurisdiction once challenged cannot be assumed and must be decided. I'm going to stop right here. On this 3rd day of December of the year Lord 2020, 28 minutes after 1, you are once more, and for the last time, on front of the United Nations, on front of the International Court panel judges, and on front of the United States and the corporate United States District Court for the Corporate District of New Mexico, you are asked once more to bring your jurisdiction, and you will not be able to do it. For the record, on this video, on front of the world, for the world to see how is it that you are proceeding. Jurisdiction can be challenged at any time. Jurisdiction, once challenged, cannot be assumed and must be decided. VESO versus Utah Power and Lighting Co. Charlie, capital O, Oscar, lowercase, 495, Foxtrot, capital, period. Number 2, Delta, lowercase, 906, comma, 910. Public hazard bondings of corporate agents. Do you have public hazard bondings? You're supposed to carry this. All officials are required by federal, state, and municipal law to provide the name and address and telephone number of their public hazard and malpractice bonding company and the policy number of the bond and, comma, if required, comma, a copy of the policy describing the bonding coverage of their specific job. And on the default judgment, you were requested for it. You were requested for it, and it states clear, it is hereby ordered the surrender of all performance and repleving bonds no later than January 15th of the year 2020, or bench warrant will be issued. Did you provide it? No. You say, hey, issue the warrant. Well, the warrant was issued. And you are hereby asked to turn yourself in, to turn each one of you to come to 333 Lomas Boulevard, Albuquerque, New Mexico, first floor. Ask for the office of the U.S. Marshal and say, I'm here because I don't want to die on the electric chair. I'm here because I'm turning myself in, and I much rather eat potatoes for the rest of my life. I'm in front of the international court. I'm in front of the federal court. I'm in front of the Supreme Court of Justice for the United States, and I want to be incarcerated. Because if I run away, I will be commuting my sentence of life in prison to the electric chair. Each one of you. Listed on the criminal complaint on this case, under this case, you were given the document. Your name is there. On the writ of mandate, page 2 of 12, and page 3 of 12 of the writ of mandate, there's all these titles that you are at bridge. And I'm going to start over here. Public hazard bonding of corporate agents. All officials are required by federal, state, and municipal law to provide the name, address, and telephone number of their public hazard malpractice bonding company and their policy number of the bond, and, if required, a copy of the policy describing the bonding coverage of their specific job they are performing. Failure to provide this information constitutes corporate and limited liability insurance fraud under Title 15 U.S.C. as prima facie evidence and grounds to impose a lien upon the officials personally to secure their public oath and service of office. You disbar yourself. You didn't provide it. You disbar yourself. What part you didn't understand? In the other courts, we have a panel of judges sitting on this document, looking at it. They have your name. They have forensic evidence you did not comply. They have forensic evidence of willful malicious prosecution. Under your insurance policy, willful malicious prosecution carries a $1 million fine. concealing this document. It's either you don't have it, you're guilty of insurance fraud, as prima facie evidence and grounds to impose a lien upon the official's personnel to secure their public oath and service of office under Title 18 U.S. Code Section 912. These are numbers. This is real law. This is where you are at loss. This is where you don't have a chance. This is where you're going to regret not reading this document. Carl W. Ravestick, you are general counsel. You are the master thief of all these people operating on that building under the facade to commit fraud. That building is just a facade to commit this fraud, this organized crime. And you are going to jail for the rest of your life. You are here commanded by the Honorable and for the Honorable Adelina Arriaga Pedrosa to come by the building at 333 Lomas Boulevard and turn yourself in. If you don't do it, you don't feel like doing it, don't do it. If you feel like taking an airplane, going to the Bahamas or someplace in Cairo or someplace where you think you're going to be safe, well, think again. Because under common law, you're going to be brought to justice from whatever place in the world is that you are under. And we don't care about the treaties, if there is an extradition treaty. This is about one of the people. To give you an idea, breaking and entering or burglary under administrative code is 30 days. Under common law, is the death sentence.